So then, I think we are ready. The door of the library is closed. Let me start. Dear distinguished guests and speakers, dear colleagues and friends, it's truly a great honor for me to welcome you all here in the prestigious Solvay Library for today's conference on company law and digitalization. Already in the past, this beautiful place was a symbol for science and discussion. In the early 20th century, here in the Park Leopold, the famous Solvay conferences took place. The most advanced scientists from all over the world of the time, like Albert Einstein or Niels Bohr, met here to discuss the newest breakthroughs in science. Well, I hope this spirit of fruitful discussions will also guide us in our conference today. As I have learned, we have more than 200 participants from all over the world, partly here in presence, and once again a warm welcome, but also a warm welcome to all those participants that are connected online to our conference. Welcome. So, digitalization and company law and digitalization. Why did we choose these topics for our conference? Well, the answer is almost banal. They are closely connected. Obviously, digitalization is transforming every aspect of our everyday life. It is also transforming how the economy, how businesses operate. This must be reflected in the legal sector too. Company law is just one, but a very important example of how digital tools and processes can make life easier for citizens, businesses, and public authorities alike. Not only on the national level, but in particular across borders. So, for instance, when citizens from one member state want to form a company online in another member state. And this was exactly the subject matter of the first Digital Tools Directive of 2019. Now, 5 years later, the new Upgrading Digital Company Law Initiative, or Digitalisation Directive 2.0, takes the next step of digitalization of European company law. One, the expansion of digital tools from limited liability companies to private partnerships. Two, the exchange of documents and information quickly via the BRIS, the Business Registers Interconnection System. And also, three, the introduction of the EU Company Certificate, and four, the Digital EU Power of Attorney. They all will facilitate doing business across borders in Europe. This will make life easier for entrepreneurs and businesses. And that is why the Commission proposal on upgrading digital company law has been published as part of the Commission's 2030 Digital Compass. It's a key initiative of Europe's digital transformation towards 2030. It is therefore very timely and very topical to discuss the Digitalisation Directive 2.0 today in our first panel. But the Commission is not only to offer the next upgrade of digital company law. Other digitalization files will help transform Europe into a digital economy. So there's the revision of the eIDAS regulation, the toolbox for electronic identification. Soon, every European citizen will have an EU wallet on the smartphone to identify electronically across the EU, to sign with a qualified electronic signature, and also upload important attributes to the wallet. And there's also the regulation on the digitalization of cross-border judicial cooperation, the digitalization regulation. The decentralized IT system e-Codex, you all know it, will be used to communicate digitally across borders to facilitate access to justice. Recently, the introduction of ChatGPT, you all know that, has brought another technological development to the forefront of public and thus also the regulators' attention: the use of artificial intelligence in the legal sector. No other technology will come as close to us as human beings as AI. So the overarching question, in my view, is how can AI help citizens, businesses, and us as legal professionals to be more creative and focus on the important tasks that need, and definitely need, human intervention. eIDAS, e-justice, AI, all great reasons to discuss the challenges and opportunities of digitalization and the rise of AI for the legal sector. I'm really eager to hear more on this topic in our second panel, where experts on digitalization from different parts of the legal world, of the legal community, will discuss the challenges and opportunities the future might bring. But before I hand over to our distinguished speaker, Mr. Ralf SAUER, let me highlight the following. The goals pursued with the Digitalisation Directive 2.0 are positively ambitious. The draft directive is about more digitalization and fewer unnecessary formalities, improved business registers and easier cross-border procedures via the BRIS, legal certainty and reliability, and also the prevention of illegal activities. We as notaries, we as gatekeepers of the registers, we all welcome this. So while many things can be discussed in more detail, there is one particular positive aspect that I would like to highlight. It is the Commission's deliberate decision in favor of public preventive control. So according to the acquis unionnaire, important company law transactions must be checked by public authorities, courts, administrative agency or authorities, and or notaries. So the Commission is now proposing amendments to the text of the relevant Article 10 of the Company Law Directive. We welcome this because member states may, or more precisely must, continue to provide for public preventive control in company law in order to protect public registers and to prevent illegal activities. In this connection, the Commission equates notarial control with administrative and judicial control. So to say, they put them on the same foot. The new recital number 9 makes this crystal clear. And this also corresponds with the acquis of the Mobility Directive on cross-border mergers, change of legal form, and spin-offs, which has also been adopted in 2019. So the explicit recognition of notarial control is justified, it's not an end in itself, it's justified by a public authority that adheres to special procedural laws and is strictly supervised by the state, and it offers a guarantee for the correctness and legality of the procedures performed by it. I slow down a bit because this is the real raison d'etre of the notarial intervention. And as much has been acknowledged by the ECJ's Unibank case, and also as stated in the Pieringer case, the underlying reason for instituting notaries as public gatekeepers for public registers is the special trust they enjoy because of their state appointment and supervision. So as president of the CNUE, let me say this: notaries perform public preventive control efficiently and reliably. Now I would like to give the floor to Mr. Ralf SAUER, who will be our keynote speaker for today. Mr. Ralf SAUER is Deputy Head of the Company Law Unit in the Directorate General for Justice and Consumers at the European Commission. His department covers company law files as well as corporate governance matters. Dear Ralf, I understand that you have just joined us from the trilogue negotiations of the Corporate Sustainability Due Diligence Directive, and you told me just up front that you are a bit in a hurry and maybe you have to leave us earlier. You feel very sorry about that. Just let me communicate it to you, but so we will speed up and so that you can get back on time to your trilogue negotiations. But I think we are all the more happy that you are able to join us today instead. So we are very much looking forward to your insights from the Commission perspective. Dear Ralf, the floor is yours.
So this has given it a bit more prominence than I wanted in terms of my availability later on. It's not for the keynote speech, it's just for the panel later on, so don't worry. Honorable members of the European Parliament, Ms. Maria Manuel Leitão-Marques, and I think MEP Andreas Schwab is also here. Dear President, STELMASZCZYK, dear panelists and guests, and I believe there's also some people and attendees online. Let me first of all thank the CNUE for the invitation to this conference and the opportunity to kick it off with a few words about the Commission's proposal for a directive on upgrading digital company law. I already had the privilege to speak about this initiative at the Conference of European Civil Law Notaries in Salzburg earlier this year, and it's good to continue the conversation today. The UCDL proposal, as we call it, was adopted in March as one of the key actions of the 2023 Commission work program under the priority Europe Fit for the Digital Age. By aiming at a more integrated and digitalized single market for companies, it responds both to the objective of further digitalization, as set out in the Commission's 2030 Digital Compass, and the need to complete the single market by facilitating the operations of business, in particular SMEs, across borders. In terms of its impact, the proposal will apply to around 16 million limited liability companies and 2 million partnerships in the EU. And thanks to the administrative simplification that it will bring, or that we hope it will bring, it is expected to significantly reduce the administrative burden for companies carrying out activities or setting up subsidiaries or branches cross-border at an amount of more than 400 million euros per year. While the proposal seeks to make use of the possibilities that digitalization offers for changing the way business registers, companies, public authorities, and legal professionals such as notaries interact with each other, the guiding principle is to do so in a proportionate way, by trying to strike a fair balance between the different interests at stake, and that also includes balancing the need for change with our commitment to respect the different national legal traditions and systems. As was the case for the 2019 Digitalisation Directive, this includes the role played by notaries in company law procedures, which the proposal preserves. In terms of content, the proposal introduces a package of measures to increase transparency about companies in the EU, improve trust by ensuring that company data in business registers is accurate and reliable, and reduce administrative barriers when companies, in particular SMEs, authorities and other stakeholders use company data in cross-border situations. So let me briefly go through some of the proposed changes. First, to enhance transparency, the proposal makes additional information publicly available, in particular at EU level through the Business Registers Interconnection System, the BRIS. This includes, for instance, information about partnerships, groups of companies, the place of central administration, and the principal place of business. It also provides for connections between BRIS and the EU interconnection systems for beneficial ownership registers, BORIS, and insolvency registers, the IRI, to facilitate access to information about companies while respecting the requirements regarding the access to each of these three systems. The second and essential element is to increase trust in company information across the EU. Correct, reliable, and up-to-date company information in registers is a prerequisite for its use, in particular in cross-border situations. To this end, the proposal introduces a requirement of preventive, administrative, or judicial control and a legality check of the instruments of constitution when companies are created, be it online or offline. This includes a list of mandatory checks, for example, of the legality of the company's name or object. The proposal also provides filing deadlines for companies to update their information in registers and for registers to make these changes public. Requires companies to confirm once a year that no changes to their data are necessary, and provides penalties for non- or late filing. Third, the reliability of company information is essential to facilitate the use of company information across borders. But more is needed to reduce the existing burdensome formalities for companies. The proposal addresses this need in a number of ways. It ensures the application of the once-only principle when companies set up subsidiaries or branches in another member state, so that companies do not need to resubmit the information that is already available in their register. It also introduces the EU Company Certificate, a multilingual, harmonized company extract that will serve as a proof of incorporation of a company in a given member state, together with certain information about the company. In addition, it introduces a multilingual model for a digital EU power of attorney to authorize a person to represent the company in another member state. Furthermore, the proposal abolishes legalization requirements like the well-known apostille for certified company documents from business registers and for certain notarial acts when they are represented in another member state. And lastly, it reduces the need for certified translation to when this is strictly necessary, for instance, for judicial proceedings. Given the important role that notaries play in company law procedures, we very much welcome the contributions from notaries during the preparation of this proposal. And as I said earlier, I am happy to have a further opportunity to exchange views with you today, which moreover continues an already long series of contacts and discussions that we have had. The proposal is now being discussed in the Council and the European Parliament. On the Council side, we already went through a first oral reading of the proposal, with the Commission providing explanations and reactions to the initial comments from Member States. The Spanish presidency will now work on a compromise proposal that could provide the basis for the so-called general approach, and we'll have to see when this negotiation mandate will be adopted, whether under the current, the Spanish, or the next, the Belgian presidency. On the side of the European Parliament, a draft report was recently presented in the JURI committee, the lead committee on this file, with a deadline for amendments, I should say, last Friday. The vote in the JURI committee is planned for November and a plenary vote for December. Our hope and expectation is that both co-legislators will be ready by the end of this year or at the latest at the beginning of next year, and that trilogue negotiations can still be finalized during the Parliament's current mandate. Based on the comments and proposed amendments I have seen so far, I can say that the reception of the proposal has been overwhelmingly positive. That doesn't mean that we haven't also received some critical comments, and as always, there is room for improvement, for clarifying certain points and strengthening others. But for now, I do not see any insurmountable obstacles that defy compromise solutions. And of course, stakeholders have a role to play during the interinstitutional negotiations. I therefore invite you to continue to constructively engage in the ongoing discussions about this proposal. And with that, I wish you all a very good and interesting conference. Thank you.